Recording in progress.
So, good afternoon, everybody. It is an honor to be here in the lecture of Professor Bruno Simma. Professor was judge of the International Court of Justice from 2003 to 2012. He is professor at the University of Michigan School of Law, professor of the University of Munich till 2003, author and co-author of about 120 articles and books, including Universals Volksrecht with Alfred Vedovato, editor of the book of the Charter of the United Nations, a commentary, co-founder of the European Journal of International Law, consultant and arbitrator in several international cases, member of the International Law Commission till 2003, a member of the UN Committee of Economic, Social and Cultural Rights from 87 to 1996. Professor Simma, it's an honor to be here. The floor is yours. Thank you so much.
Thank you, Mr. Professor Vedovato. The pleasure is all mine and the honor is all mine. And let me thank particularly Professor Leonardo Brandt for having invited me again to this lecture. I still remember last year at that time when online lectures were new and strange, and probably nobody would have thought that a year later we would still sit there and work virtually. But it's better than nothing. But I have to say that I still hope that to be reinvited at a time when that means coming to your beautiful country, which I still remember. I was there for the first time in 2005. It's incredible, 16 years ago. And I still remember the very interesting time I had, an interesting contact with students. I still remember in my lecture in about the third row, there was a guy who was always looking at me. And I thought, what is this guy? And then it turned out that he had drawn a caricature, a very nice picture of me, which I still keep. So this is probably not going to happen this year, but let's make it as living and interesting as we can. I've just heard that you have had a lecture by Professor Alain Pillet, who is really a big friend of mine. And Alain Pillet, about 20 years ago, wrote a paper, actually in honor of a Brazilian international lawyer, I think Amado, who, with the title Les droits de l'hommiste, the human rightists, in which he kind of criticized international lawyers, activists or two activists in human rights matters, and seeing international law through the lens of human rights, and considering international law to be further advanced where it in reality isn't, or not advanced where in reality it is more advanced than he thought, etc. But I had the honor to fare as what he called a moderate, kind of a reasonable droit de l'hommiste. And I think that's a good capture of what I am. I've never been a great human rights activist, I have to say. I confess it. My first wife, always told me, Bruno, you are an American Express card human rights lawyer, by which she meant you don't go to any Maveas, you don't go to any, at that time, Kosovo or even farther away. You only go where you have nice hotels, where they accept a credit card, and you can have nice dinners after a day of human rights work, quote unquote. All right, that's what I am. So my outlook at human rights and the impact it has had on international law has always been that of an observer. Of course, a very, well-intentioned observer, but a bit like somebody in a laboratory where you have a mass, which is international law, or maybe the ICJ, and then somebody comes and throws some substance, mixes some substance into the mass of substance that you have. And then you just watch the reactions. What is it? Is it going to be, will the mass show some reactions? Will the reaction be friendly? Will it be violent? So that is my way of looking at these things. Now, of course, the ICJ, consisting of a lot of elderly people, never becomes violent in any physical sense. But let's see how they reacted to having to do with human rights. My plan for these two lectures is as follows. Today, I'm going to start with telling you a few basic facts about the ICJ, very few, and my impression of what the ICJ really, what kind of court it is. Then just lose a few words about what do I mean by human rights, because after all, I'm teaching the ICJ and human rights. So what human rights are reasoned about are in contest before the ICJ. And then we turn to the way the ICJ has dealt with human rights. And there I'm going to first give you a story, just march through the years and march through the cases and very, very briefly illustrate the cases. That is, so the first part will be a development of the jurisprudence of the case law on human rights. And that should be as far as I want to come, as I want to get today. And tomorrow we would look at legal political context, limitations, prospects for future developments and things like that. And then we will have an hour or so for questions coming from the audience. Okay. So first, what kind of animal is the ICJ? And of course, it's always with a bad conscience that I ask these questions, because I remember that Professor Leonardo Brown many years ago sent me a big tome on the ICJ. That's probably the tome that all the students have to digest. I hope not really, but let me just focus on a few key features. The ICJ is different from other courts. It is the court, you can say, the court of the United Nations, the principal judicial organ of the United Nations. It has a place in the Charter. A few articles in the 90s in the Charter deal with the court. Then the court has a statute, and compared to the Charter, which of course dates back to 1945, the statute in essence was much older, because this court, the court I'm talking about, was established about more or less almost precisely 100 years ago. So it's the oldest institutionalized court that we have in the world today, which of course it's great. It's great to be old. No, not really. But for a court, it's probably nicer to be old. So, and of course it has a lot of dignity, etc. If you are a member of the United Nations, you are a member of the court in the sense that you are a party to the statute. That is also nice. What is less nice is that, of course, you pay as a member of the UN, you pay your membership fees, and the ICJ lives off these membership fees. For instance, I'm getting a pension from the ICJ itself, and that pension is into a very small particle also paid by the audience that I have before me. If the audience is paying taxes in a country, the country will be a member of the UN. So thank you very much, actually. All right. Now, the most important feature of the International Court of Justice is, however, that even though it is the court of the United Nations, the principal judicial organ, its jurisdiction is based on consent, which means if you are born into Brazil or if you're born into Germany and you grow up and you have to do with the courts, you will have to take the courts, you'll have to accept what they say more or less within the law. This is different in the world of international law. A state is not per se, not because it exists as a a party to the court. It cannot be brought before the court. It has to accept the activity, the jurisdiction of the court in each case. And let me just very briefly say, how can that acceptance take place? Well, the first, of course, the most important way is to accept the jurisdiction of the court by signing and becoming a party to a treaty. Now, there are some treaties, very few, the whole content of which is just the, let's say, establishment of jurisdiction of the court for a number of states. In your continent, this would be the Pact of Bogota of 1948, the American Convention on the Peaceful Settlement of Disputes. We in Europe have a counterpart, a European Convention of 1957. So there are a few of these treaties. I am at the moment a judge ad hoc for appointed by Chile in a case which Chile has with with Bolivia, and a little river that runs from Bolivia, kind of flowing from Bolivia into Chile. And the jurisdiction in that case is based on the Pact of Bogota. So this is one possibility. Another possibility is that you have a multilateral treaty, like we are going to encounter in my lecture, the Vienna Convention on Consular Relations in a couple of cases. And these multilateral treaties contain a compromissory clause, which is one of the articles in that convention says, if a dispute arises about the application or interpretation of the convention, which cannot be solved by other means, maybe even by arbitration, and after certain steps are taken, you can go to the ICJ. Vienna Convention system is a little different because there you have not a clause in the Vienna Convention itself, but you have an extra treaty appended like a backpack to the convention establishing jurisdiction. You speak of compromissory clauses in this case. And you have about 300 of such treaties in the world today. I think the most interesting and the most effective way of establishing the jurisdiction would be by what we call special agreement. That means states have a problem, they have tried to solve it or not to solve it, the problem doesn't go away, and for some reason they agree, let's take it to the ICJ, let's take it to the ICJ. And I think from the way I described it, you can probably guess that this is going to work better because states are really, both of them are ready to get to The Hague and put their view there and hope to win. That will work better than in a treaty that about, let's say, 60 or 70 years ago, you have given your okay to ICJ's jurisdiction, and suddenly your neighbor pops up and sues you, and you have, and you would run, but you cannot because you're bound by that within that jurisdiction. Okay, so that will be establishing a jurisdiction by a treaty. Another way is what we call compulsory jurisdiction, the establishment of compulsory jurisdiction, which you find in Article 36 of the statute. A state declares that it will accept the jurisdiction of the ICJ vis-a-vis any other state accepting the same jurisdiction. You have 74 states who have made these declarations. In almost all instances, these declarations of willingness to be torn before the court is subject to reservations. That is, for instance, Germany is always very, let's say, keen that nothing stemming from World War II will end up before the ICJ, or the activities of the German military will be kind of immunized from the ICJ by a reservation. Okay. Now, I've just looked at the numbers today and names, and I've seen that from South American countries, only Paraguay, Peru, Suriname, and Uruguay have accepted compulsory jurisdiction. Let me just say that the the expression compulsory jurisdiction is really nonsense, because if you accept the jurisdiction by way of a treaty, that is as compulsory as if you accept it by that unilateral declaration, which meets another state's unilateral declaration. Well, and finally, there are very rare cases where one state takes another state before the ICJ, and there is no jurisdictional basis, but for some reason, the other state says, all right, I can live with that, I accept. That happens rarely, but I was on the court when such a case happened. That was a case that Djibouti brought against France, and maybe we have a little time to talk about that case, etc. Okay, now the bottom line of this is you have this great international, let's say, court of justice, but its jurisdiction is not strong. I mean, the system lives of consent. Well, the consent might have been given a long time ago, but it is not like the European Court of, let's say, the Court of the European Union or the Inter-American, some regional courts that sit on a system of regional integration, which have a much stronger jurisdiction. But now comes the good side, the impressive side. The competence of the court is a general competence. Then the ICJ is the only court in the international law world which can deal with every question of international law, whatever its subject matter is. So you can, as a judge there, have the pleasure of brooding over a boundary between two African countries, and a month later you deal with a case which has to do with sanctions against Iran, and then another month later you deal with a human rights case. That makes life at the ICJ as a judge particularly interesting for an academic international lawyer, as you will guess. Let me just say the procedure before the ICJ, well, just in very, very, let's say, in a quick way, in a contentious case, there are two kinds of cases, or two kinds of procedures. The court may be asked to give an advisory opinion. That will be done by the General Assembly of the UN or by the Security Council, by certain other institutions. Okay, so that's fine. For me, in my context, what is more interesting are so-called contentious cases. That is, case state A takes state B before court. That happens as a judge of the ICJ. You notice that you're getting packages in your office, and the package will be the application, the so-called application of the claimant state, and that will be followed by huge numbers of pages, so-called briefs or memorials, counter-memorials, replies, rejoinders, which is a lot of paper that you are supposed to read. Then you have a first deliberation. I've had one of these just last week in case of my this Chile Bolivia affair, where the people have some general introduction, a general discussion, and then decide whether it would be worthwhile or necessary, for instance, to have to appoint experts that go to a certain countryside which is in dispute, things like that. All right. Then you have an oral. Then you have the hearing. Well, oral hearing is a bit of a pleonasm. And then you have a hearing. Usually takes about a week or so. During that hearing, what distinguishes hearings before the ICJ from hearings in the courts that you might have observed is that it is a very ritualized hearing. It is not like, for instance, before the American Supreme Court, where you have that lawyer well prepared saying, I don't know how they address themselves. And then after 30 seconds, one of the judges says, listen, friend, we know all that. We have read the papers. So let me ask a question. And then the guy is being, let's say, more or less tortured up there by questions, etc. At the ICJ, there is no danger. You read your papers. I remember I owe to Alain Pelé my first appearance before the International Court of Justice, which was in 1990s, in the mid-1990s, where he said, and you must read every word. I do not, he was the team leader, and as you probably might have seen from his lecture today that he can be very energetic. I remember Alain Pelé telling me, tu sais, Bruno, j'aime être tough. I love to be tough, which is great. So he was a good team leader, and he said, you just read. You just read. You do not a word, that you might think of, or a good comparison or something. So for the judges up there, things are a bit boring under these circumstances. If you have one and the same professor in very bad English speak to you for 3 hours on some problem in a foreign region or in some desert, this will be problematic. But I can't go into details here, of course. Then after the hearing, you are supposed to, there's a meeting of the judges or a deliberation of the judges, and the judges have to speak in a certain order. That is, the youngest judge speaks first, even though, of course, the judges ad hoc are really the first. If you have a judge ad hoc, I probably don't have to explain what judges ad hoc are. That is, the ICJ has 15 judges, and if countries appear before the court which do not, quote, have a court of their nationality on the bench, they may appoint somebody as the judge ad hoc for that case. And these poor people, usually speak first and state their views. Now, after 3 or 4 days, etc., it will be clear where the majority lies. And then the president of the ICJ appoints from the judges that are in the majority a so-called drafting committee. And this drafting committee will then meet and write up a draft text of the judgment. This draft text then goes to the other members. The other members have various opportunities to state what they agree with, in more also with regard to, let's say, formalities of the judgment or substance of the judgment. And then come 2 so-called readings, and that is the text that the judges have before themselves. The text is being read, and at first reading, the part of the text which is not just a summary of the arguments of the parties, but the court's own speaking. That is, the court says, according to the court, etc. All of this is read out both in English and French and then discussed. At the end of the first reading, the judges are asked, do they plan to issue an opinion that is either a separate opinion, that is an opinion in which they agree with the outcome of the case, but have extra or different reasons, or a dissenting opinion, which means they're going to vote against the dispositive of the judgment. They have to write the opinions pretty quickly to give the drafting committee an opportunity to build into the judgment whatever they can accept from these opinions. Then there will be a final version of the judgment, and at the end of the hearing, a deliberation, a vote will be taken, and that's it. And then the judgment is read out in a public sitting. Usually what I did during these public readings of the judgment, because you know what's in the judgment, and you don't want to listen for 1.5 or 2 hours to the text that you know by heart and you have had nightmares about. But what I always did, I read the dissenting and separate. The most interesting always were the opinions and views of my Brazilian colleagues on the court. And they were usually very long, so you had enough interesting readings for the entire time that the president read out the judgment. Good, so much about the procedure. Okay, now, what did the court look to me? What did it look like? And to me, it looked like, I would say, a civil court, that is actually a court dealing with civil matters. What I mean by this is that, for instance, and very importantly, there is no element of criminal jurisdiction or no element of accusation of a state of a behavior that, if it can be transposed to the domestic scene, would lead to a criminal case. Nothing of that is there. It is really like civil court. Of course, you have the international criminal courts for, let's say, violations of international law that are supposed to be international crimes. So there is a division of labor there between two courts in The Hague. But the ICJ deals with applications by one state against the other. But of course, the subject matter or the content of the claims can be very different from what you would meet in a civil court. And here, and then you can see there might be cases coming the way of the court that really kind of strain the court. And one good example were the genocide cases that I observed while being on the court. Of course, you can see the Genocide Convention, that is a convention which obligates states to prevent and punish genocide and do something against commission of genocide by other countries. Of course, is something which really very heavily smells of criminal law. It is a crime. It is the utmost international crime. And to deal with something that is considered to be a crime in a court which is more or less has the structure and the limitations of a civil court will be very, very difficult to handle. And I'll get to that later. For instance, the ICJ does not have any independent fact-finding capacity of its own. Very different from the international criminal courts, where if you look at the budget or at the number of people that there, the huge majority of people will work for the prosecution, that is, they will do the fact-finding, etc. And the court is more or less a small group among the entire crowd. The ICJ, there is just the 15 judges and very few lawyers around these 15 judges. And nobody, if the court wants to look into a subject matter, like where does the boundary actually run, or who has been there at a certain time, you have to appoint an expert, which is a very, very, let's say, a really rare occasion. Okay, now, second preliminary matter. I'm dealing with the ICJ's work on human rights. So what are the human rights we talk about? And here the answer is a very positivist, very technical answer. The ICJ that the human rights the human rights that the ICJ applies in a case, the human rights that it considers to be obligatory, etc., are the human rights that you find in public international law on human rights. So this is not the matter of philosophy or morality. The human rights before the court will be the human rights that you find in the form of international treaties, for instance, the international covenants on economic, social, and cultural rights, or covenants on civil and political rights, the Racial Discrimination Convention, the Convention Against Discrimination against Women, etc., etc. So the big human rights treaties. And then there can also be a a category of human rights law which is based on customary law, there is no treaty there, but there is a very strong conviction that something is binding on a state even without a treaty provision, let's say, working in that direction. Actually, if you look at the advisory opinion of the ICJ on the reservations to the Genocide Convention, I'll be there in about 5 minutes today. You see that the court there says the Genocide Convention, the main obligation in that convention is an obligation which is binding on all states, even without a treaty commitment having been made by that state. And so if you look at sources and if you stick to a relatively conventional image of sources, which the court will do, this has to be customary law. So we are talking about the treaty law and the customary law on human rights. And of course, the basis that the ICJ has, or the provision which indicates to the court, these are the rules or these are the sources that you need to apply, are to be found in Article 38, familiar to all of you, treaties, there's conventions, customary law, and general principles of law. Of course, the question is, how does the court deal with the so-called soft law? That is law, that is principles enunciated almost like a treaty, but intentionally not given the binding force of a treaty norm. Of course, with the prospect that this will turn into a treaty later or will become binding when states adhere to it and customary law emerges. But soft law is not binding at the outset of that. And of course, most of soft law remains soft. And then the question is, what does the ICJ do with such soft law? And it does precisely what you expect. It will refer to it. For instance, it will refer to the Universal Declaration of Human Rights of 1948 or of the Friendly Relations Declaration of 1970, I think. But it will not say, and you are bound to, or you have violated international law if you have acted against such a rule. It will always keep the distinction between the hard law and the soft law. So I think you can say that the methodology of rule finding and applying of rules of law by the ICJ is not terribly, let's say, neo or the postmodern one. It's a very positivist one. I think it's necessary for the court to handle things in that way. All right. So this is my introduction, and now I turn to the story of the development of the fate of human rights before the ICJ. And here you can more or less ask yourself two questions. You can say, well, what is has the development of international human rights had an impact on the attitude of the ICJ, on the jurisprudence of the ICJ? Or you can ask the questions the other way around. Has the jurisprudence of the court had an impact, led to a certain development of human rights out there in the world? And you can look at everything I say from now on from both of these angles. If we turn to the jurisprudence of the ICJ, I think we can really distinguish two phases in the development. A first phase, which is marked by a certain restraint on the part of the court and also of the states that bring cases before the court. That is hesitation, restraint, and that phase is over. And we are now in a second phase in which a greater degree of readiness of states to bring human rights cases before the court can be seen, and also a greater degree of readiness by the court to deal with these cases in a, let's say, an adequate way. Okay, now let's see, what do I mean when, say, the first phase is one of hesitation and restraint. Well, maybe just a mini anecdote. When the UN Commission on Human Rights in the early in 1946, 47, 48, when it elaborated the Universal Declaration of Human Rights, they also discussed the question: should these rights be judiciable? Should there be any monitoring? And a state brought up the possibility: couldn't we ask the ICJ for decisions or on what these rights mean, how far these obligations range, and then we would be bound on that. And this initiative ended in total failure. Nobody wanted to, let's say, put human rights matters before the court. And I think the reason for this was that during the interwar period, when you had the predecessor of the court, namely the Permanent Court of International Justice, dealing with matters, let's say, that really concerned human beings or members of minorities, you have to say that the jurisprudence of the ICJ was very etatist, very statist, very state-friendly, very sovereignty-friendly. And of course, that was the expectation people had in 1945. And the good news is that this expectation was not really fulfilled, at least not as totally. But at the beginning, a very slow process got into motion. Of course, if you have an international law developing in a certain way, let's say by the United Nations, for instance, and then you have a court which has jurisdiction to deal with these matters, if conflicts arise, you will see that there is going to be a link between these two sides. That is, if a subject matter is in its very early phases, if it slowly comes about in the form of soft law, etc., etc., not many things will end up before a court. But if the law thickens and if the law widens, then of course courts get work to do, and that is precisely what we see here. In a first group here, you can say human rights are mentioned, not really developed by the ICJ, but the human rights questions appear in more or less incidental ways. That is, the legal reasoning in essence turns around matters which have nothing to do with human rights, or in regard to which human rights played a very subordinate role, and were thus treated by the court more or less as obiter dicta, and not in a fully developed or even fully welcoming way. And the first example would be the Corfu Channel case. The Corfu Channel case, decided in 1949, actually the first judgment of the ICJ, dealt with matters very far away from human rights, namely an international waterway between the Greek island of Corfu and the state of Albania. I had the pleasure in 2014 to go on a cruise in the Eastern Mediterranean, and I remember how excited I was when the cruise ship passed the Corfu Channel, and I was surprised how narrow it was. And the question was, there were mines there, and then some ships, let's say, hit the mines so the British Navy just sent a few warships through that channel and had the mines cleared. And then that case came before the ICJ. And what human rights? Well, there is a passage in one paragraph in that judgment where the court speaks of obligations that coastal states have to see to it that no dangers arise from ships passing through their territorial waters. And the court speaks of, I quote, obligations based on certain general and well-recognized principles, among them elementary considerations of humanity. So these words, the term elementary considerations of humanity, that are to be found even in the law of the sea or in maritime warfare. This was the first mentioning of human rights in a decision by the ICJ, 1949. Now, I'm making quite a jump now from the Corfu Channel case to the Barcelona Traction case, which was decided in 1970. And you might have heard that in that Barcelona Traction case, the ICJ for the first time spoke of so-called erga omnes obligations erga omnes. And in a case where you wouldn't expect, again, like Corfu Channel warships, World War II, Barcelona Traction, the expropriation, illegal expropriation of a Canadian-Belgian company in Barcelona who had been there in let's say, looking for the water and electricity. And it dealt with actually the question, should the home state of the investors or the state in which the Barcelona Traction has been, let's say, established, be the state who has the right to look after or to protect the rights of shareholders, the rights of the company. That is a very, very fundamental international economic law question. Nationality of corporations, protections of shareholders. And in the middle of this world of economy and money and so on, there suddenly pops up this paragraph which says, yeah, these obligations on diplomatic protections, they always work bilaterally. But there you have other obligations erga omnes. And let me again quote, such obligations derive, for example, in contemporary international law from the outlawing of among other things, genocide, as also from the principles and rules concerning the basic rights of the human person, including protection from slavery and racial discrimination. Full stop. And the next line is again with, shareholders' rights, etc., etc. And you just wonder, what was that? Did they overlook something when they drafted the judgment? No. It was the other way around. I said 1970. In 1966, 4 years before, the ICJ had decided a case which was highly political, and of course, you can say a human rights case in that sense. It dealt with Southwest Africa. Now, Southwest Africa had been a German colony. At the end of World War I, the people they couldn't really agree who could get the booty of the German colonial, let's say, territories. And so they established what they called the mandate system, which means the UK, France, South Africa got certain territories, but they had to somehow treat these territories as different from their own. They couldn't simply just rob it or take it from the, let's say, the states that had lost World War I. So a system was established under which the state who had gotten that territory, quote unquote, had to see to it that the population was treated in pursuance of, let's say, elementary, let's say, decency. I mean, we're still talking about colonialism in 1918, 1922, whenever. And South Africa had gotten the mandate over Southwest Africa. And while after World War II, all these mandated territories, these mandate systems were abolished, South Africa had turned to apartheid policies and just stuck, did not let free Southwest Africa. And that led to a whole number of decisions and advisory opinions by the ICJ. But nothing really, I mean, you couldn't get the South Africans out of Southwest Africa. And so in the late 1950s, two countries, namely Liberia and Ethiopia, they were the only African countries that had already existed during the League of Nations period, took South Africa to the ICJ in a contentious case, claiming that that South Africa was violating the obligations under the mandate by apartheid. And after a long and very, very expensive procedure, the court in 1966 came out and said, well, we are sorry. The only institution that would have the right to claim the non-performance of mandatory obligations by South Africa would have been the League of Nations, but unfortunately, the League doesn't exist anymore. Ethiopia and Liberia do not have a standing in regard to this. Outcry. I remember I attended the Hague Academy of International Law for the first time in 1967. And I remember one of the lecturers telling the story that in 1966, following that judgment, there were a budget, deliberations in the United Nations, out of which there came a pay raise for everybody in the UN, everybody except for the judges of the ICJ, because the political correctness at the time was very much against the court. And so the court felt under heavy political pressure, and especially, of course, the socialist judges on the court, among them the Judge Manfred Lux from Poland, at that time, communist Poland. And Manfred Lux managed to smuggle or insert into that judgment that famous paragraph of obligations erga omnes, which was designed as a sign to the world, listen, we want to do good. We are not going to keep to this colonialist traditional system. Okay, so that, but you can see, I mean, the court, the first category of cases that I deal with are supposed to be cases in which something was said about human rights, something that remained relevant, but the cases themselves were no human rights cases. And the last of these cases was a case which is of some concern to me at the moment, because I'm my 9th year as a judge arbitrator in the Iran-United States Claims Tribunal in The Hague. This claims tribunal owes its existence to the Tehran hostage crisis. In November of 1979, over 50 US diplomats and consular officers were taken hostage by the Iranian, by the mullahs, and remained hostages until January 1981. The problem was solved by the mediation of Algeria, and the so-called Algiers Accords were concluded, under which the hostages were freed and the sanctions were to be taken back as much as possible. The United States, which it very rarely does, went before the ICJ in 1980, already 79, and the ICJ dealt with the case and called the hostage-taking, I quote, incompatible with the fundamental principles enunciated in the Universal Declaration of Human Rights. So you would have a reference to soft law by the ICJ. Okay, so this was, again, where am I in my systematics? I'm in my first cluster, which is a first period marked by hesitation and a certain restraint, and a subcluster in which you had cases on all kinds of subjects, and there is a mentioning of human rights here and there, but that's all. Now I get to a second subcluster within that first period, and there you can say human rights were of greater importance in these cases. They were not just let's say, something clicking off as a statement, but they were still more in the nature of an occasion for the court to engage in discussion of matters that were different from human rights. even though the subjects these matters concerned or dealt with were human rights matters. And the most famous of the cases in this regard is the advisory opinion of the ICJ, rendered in 1951, on reservations to the Genocide Convention. Well, if we had a real class now, I would say, just tell me what was that about, so I have to do it myself. That is, you had the Genocide Convention, 1948, and of course, states started signing up to it and ratifying it. And then you had the Eastern European countries and the Soviet Union, Eastern European countries that had gotten communist regimes in the 1947s, 48s, and they said, of course, we are all happy about the Genocide Convention, but we are not going to sign up for the clause, I think it's article, I forgot actually, which says if there are disputes arising that cannot be settled otherwise, any state might take another party of that Genocide Convention to the ICJ. And these states made reservations. They said, we are all for a prohibition of genocide. We have never committed. We are never going to commit, of course. But we don't want an institution like the ICJ, which we consider to be old-fashioned. Then, of course, Soviet Foreign Secretary Litvinov, when the Soviet Union was accepted in the League of Nations in the early 1930s, had said, nobody can be objective in Soviet affairs. That is, courts cannot be objective, so we are against courts. Everything has to be settled by diplomacy or by force. So reservations were made. The United States, on the other side, got a number of Latin American countries, particularly, to protest in the General Assembly and ask for an advisory opinion of the ICJ on the matter. And the ICJ rendered an opinion, which is more or less, you can see, which led to the modern law on reservations to multilateral treaties. Namely, they said, yeah, reservations can be made. The situation is different from the League of Nations period. The emphasis now is not so much on the integrity of the treaty obligations among all member states, because now we have that the aim is universality, as many states getting under the umbrella of a treaty as possible. But there might be necessity for states to exclude one or the other matter. And then the court said, yes, they can do so. But if the matter that is to be excluded goes against the object and purpose of the treaty, then this is an impermissible reservation. And other states don't have to accept it. They can object to the reservation, and then they can regard the other state not as a party to that treaty in question. So very important. But of course, the advisory opinion is not just remarkable or applicable to human rights treaties. It can have in mind all other multilateral treaties. So that's what I mean when I say some more was said, but the Genocide Convention advisory opinion deals more with the development of a modern law on reservations than with human rights matters. And another case of that nature was also in the years of the emergence of the Cold War. That was an opinion on the interpretation of peace treaties with Bulgaria, Hungary, and Romania, also rendered in 1950. You had peace treaties with these countries concluded after World War II. And these peace treaties had arbitration clauses, and a certain way that the arbitration tribunal had to be set up. Like if a country wanted to go against Bulgaria and maybe complain about the treatment of the political opposition in the newly communist Bulgaria, and of course you had terrible, horrible years of political persecution, etc. in these countries. If a state wanted to against it, it appointed an arbitrator, then the other state, like Bulgaria, Hungary, Romania, had to appoint their arbitrator, and then the Secretary General of the United Nations would appoint number 3, and then the 3 could go to work. Now, of course, what happened was that these countries simply refused to appoint any arbitrator and hoped that the method would be dead. Against this, Western countries argued, well, then if they don't appoint their arbitrator, then the UN Secretary General should appoint an arbitrator. This was taken to the ICJ, and the ICJ decided, no, you cannot really do that, because this is against the nature of arbitration as a voluntary submission. And it's also would have the effect that at the end you would have 2 arbitrators. And you can imagine that in an arbitration where you only have 2, it is difficult to find a majority. All right. Then you had a number of cases that had to do with Southwest Africa, where the situation was, as I already described. Now, the United Nations was of course, very unhappy with the situation. And so there were a number of advisory opinions by the ICJ on questions like, is Southwest Africa, is that the question that we can regard a question for which we are competent? I mean, we meaning above all the General Assembly of the United Nations. ICJ said yes. Then another question arose, are we competent to supervise the international status as still a mandatory mandate? Yes. So what can we do? And then the ICJ came out and said, yeah, you are competent. Of course, the League of Nations, your predecessor in these rights, doesn't exist anymore. But as long as you act, as you make decisions, as you monitor in procedures that are as closely following the procedures in the mandate system as possible, then you are fine. For instance, also with regard to the question whether people complaining about their treatment in Southwest Africa could come to the UN. So you have a whole series of decisions dealing with human rights. I mean, you've all heard about the Nicaragua judgment, Nicaragua 1986, that is the merits judgment on Nicaragua. There in the judgment, you find one of the issues is can a third country intervene in the domestic affairs of another country, or in a case like that between El Salvador and Nicaragua at the time? And the court said just in one sentence, well, whatever, a use of force is not an appropriate method to enforce human rights. Okay, right, not more, but that was quite clear. And then you had, these are the last 2 cases in this, my second subcategory. You have 2 cases that have to do with the human rights machinery that was built up. Within that machinery, what you had were rapporteurs on, let's say, a UN special rapporteur on either a subject matter like torture or the food situation, like Palestine's treatment by Israel, or you have particularly country rapporteurs. And there were 2 rapporteurs who got into trouble with their home countries. The first was a Romanian. This was in the late 1980s. Romania still deeply communist and, of course, suppressed this political system. He was not allowed to travel to Geneva and present his report because he was too, let's say, human rights minded, too little communist. And the UN went to the ICJ, and the ICJ rendered an opinion and said, listen, these people, the special rapporteurs, are so-called experts on UN mission, experts on mission. And as experts on mission, they enjoy all the functional immunities they need to perform their job. And that means that, of course, a special rapporteur has to be, you have to let him out of the country, go to Geneva, present his reports, and do his work. So this was Matsilu in 1989. And 10 years later, you had a case involving a special rapporteur in Malaysia. He gave lectures in Malaysia on freedom of the press and said things that a lot of people in Malaysia did not like. And so in some of these common law countries, if you really want to legally kill your opponent, you take him to court for libel. And so this poor special rapporteur faced libel cases in Malaysia, which if he had lost them, he would have had to pay over $100 million, which of course is the civil death of a person. But again, the UN went to the ICJ and got an advisory opinion, more or less repeating what the court had said in the Matsilu case. This is the so-called Coomaraswamy case of 1999. All right. Okay. So now just a few words on some kind of a middle range of decisions here, which I'm not going to deal with in any detail, which is self-determination. The ICJ has rendered a number of important cases on self-determination of peoples, but that would be a subject of its own. The reason why I mention it before I continue on my way is that because the UN doctrine since the 1960s has been that it makes, maybe I'm putting things a bit too black and white, but I think the doctrine is, it makes no sense to speak of individual human rights as long as the people that we are looking at in that regard do not have not enjoyed the right to self-determination. So self-determination is, if you want, a collective human right, which is the basis of all other human rights. That is the official UN doctrine. And of course, there were cases in that regard which would really deserve a lecture of their own, like the Southwest Africa cases I've mentioned, the Western Sahara case, the East Timor case, or the Wall opinion of 2004, in which I have participated, or the very latest one is from 2019, is a case on the legal consequences of the separation of the Chagos archipelago from Mauritius in the 1960s by the United Kingdom. Okay, and unfortunately, I look at the watch, I'm already late, so I am just concluding this chapter. Now, okay, now I come to some kind of a in-between insertion in my systematic, and this is, I referred to a number of judgments in which states were found to be in breach of obligations deriving from the 1963 Vienna Convention on Consular Relations, and individual rights became a subject of the discourse and of the judgments of the ICJ, but the ICJ did not consider them to be human rights. These cases are the Lagrand case, where there was one involving Paraguay before. What is the name? Okay, but it didn't really get very much before the ICJ because Paraguay withdrew the case after its nationals. So Lagrand, two brothers having a German mother. The German mother got these kids from American soldiers stationed in Germany. One of these soldiers kind of went to the United States and took the two kids and the mother with him, and he adopted these two brothers. His name was Lagrand, so we are speaking of the Lagrand brothers. These Lagrand brothers committed a crime in Arizona. They killed one person, and they ended up on death row in the United States. One reason why they were sentenced to death were particularities of the U.S. criminal procedure that I cannot go into detail. But I mean, more politically, you can say that well, again, it's a bit brutal against the US, but I think it's still true. If you are poor and if you cannot afford a good criminal defense, your chances of ending up in a death cell are larger than otherwise. And of course, these people did not have a decent offense. They got one of these lawyers delegated by the state, and at the end, they learned rather late that they were actually German. They wanted to get in touch with the German consulate, but by the time that happened, everything was too late. They had been detained. They had gotten their criminal procedure. They had gotten their death sentence before Germany could step in. And Germany regarded this as a violation of a right under the Vienna Convention on Consular Relations, a violation of a right that you have to get in touch with your consul, and the consul would then be expected, of course, to do something for your criminal defense. Okay, this right was violated. The ICJ decided in 2001, yes, indeed, the United States had violated the Vienna Convention by not informing the Legrand brothers of their right to get in touch with consulate. And the United States had, when such cases were to occur again, to do everything they could within their own choice of means to really prevent this from happening again. The Legrand. Mexico, a few years later, had a very similar case, the so-called Avena case. They had about 50 Mexicans on death row in the United States. Some of them were executed, and Mexico went to the court. But in both cases, and this is why the case has a place here, the court said, yes, the Vienna Convention establishes individual rights of the persons concerned, rights that can be enforced by the home states of these persons. I was more or less the guy, the academic in charge of that case for Germany against the United States. And I remember, I will never forget the afternoon in which I had to plead that this right to the right to information about consular assistance had become developed into a customary human right matter. There was a decision by the Inter-American Court of Human Rights rendered just before our proceeding, in which the court had said that. The court had said that if such a negligence, a neglect of information occurs in the course of a criminal proceedings where the death penalty is threatening, this is an essential violation of due process and has to have consequences. And my task was to claim that this right had become a customary law. The court said, you have an individual right, but since we recognize this individual right that can be used by Germany, like before the ICJ, since we say yes, there's an individual right, we do not have to go further and decide whether this right is now a human right. Mexico asked the same question and again got a negative answer. Why are these cases relevant? They're relevant because you see that an important step by the court was to say, yeah, it is possible that individuals have rights under international law as such, but this does not necessarily mean that we are dealing with human rights. And so I thought in a lecture on the ICJ and human rights, I think you at least have to spend a couple of minutes on the cases where the court said, listen, not every time the individual interest or rights of a person pop up, we have to do with this heavy category, particularly important category of human rights. Very recently, the Vienna Convention on Consular Relations, the same subject matter, has played an important role in a case between India and Pakistan, the so-called Jadhav case. Jadhav is an Indian national. I think I can say is, because contrary to the Legrand brothers, he was not executed. I think he's still alive. I tried to do a little Googling, but I couldn't really find something clear about that. Jadhav was an Indian who was accused of espionage in the neighbor country Pakistan and sentenced to death there. And India took Pakistan before the ICJ, and the ICJ reaffirmed what it had said in the Legrand and Navina cases, that there is this right and of course you can see that an Indian spy in a Pakistani prison was probably not treated very nicely. And among the things that he did not receive was the contact with the Indian consulate. And the court said this was a breach by Pakistan. Okay, good. Now, the more recent picture. The stories I've told you now were all stories which had to do with human rights, but they were not really heavy human rights cases. And this picture has begun to change since, I would say, probably the turn of from the 20th to the 21st century before the eye. Human rights cases have become more prominently on the court's docket, and they have come in a bit of larger numbers, even though, of course, speaking of large numbers of cases before the ICJ is a topic. The ICJ renders maybe 4 to 5 judgments per year. And so to say that human rights cases come up in large numbers have to be seen, how should I say, more or less to the opposite lens of a microscope. I mean, we don't have large numbers there. But human rights cases have become more important. I'd like to turn to this development now. There was a gradual build-up here, a gradual build-up. The gradual build-up started with an advisory opinion, namely an advisory opinion on the legality of the use by a state of nuclear weapons in armed conflict. The opinion was rendered in 1996. Of course, you can see that this is a highly political question. The court was very, very, very uncomfortable with that question, and actually did not declared that it was not in a position to really answer the decisive question in that case, namely whether nuclear weapons could be used in cases of self-defense and threat of the existence for a nation. So a terrible case for the ICJ, of course, but the court also looked at, is there a human right to life, which of course you find, for instance, in the International Covenant on Economic and, on Civil and Political Rights. And the court said that the threat or use of nuclear weapons can result not only in violations of international humanitarian law, but also of human rights law, properly so called. Okay. Then you could call the wall opinion. I mean, you see, when I speak of gradual development, I do not follow a clear, let's say, course through the time, like first case 96, then 97, 98. Sometimes I make a jump, and that means that I do a bit of force. I apply a bit of force to get my cases into the system, because the next one I have on my list here is the wall opinion, rendered in 2004, in which the court said that the separation wall, which Israel has built, does not follow the green line, which is the official separation line between territories which are internationally recognized as belonging to Palestinians and on the other side belonging to Israel. But the wall runs on Palestinian territory, and therefore the course of that wall is illegal. And there's of course consequent illegalities. And one of these illegalities would, for instance, be the violation of rights of Palestinians to have free access to their agricultural properties, etc., etc. This was interesting because it was the first time that the court mentioned the International Covenant on Economic and Social and Cultural Rights as a covenant that could be violated. Again, a topic for a lecture of its own, because the legal nature of the obligations under economic and social rights is a difficult, kind of slippery topic. But in the Wall opinion, the court said, and actually there is, at the United Nations, there's some kind of a registry kept, there's some kind of a mini institution established, a registry kept, which kind of collects the numbers and statistics on damages done to Palestinians by the way Israel handles the war. Then you have, this was 2004. Now we have 2005. For a change, we follow the chronology. 2005, a huge case was decided, Congo versus Uganda. You had in the late let's say in the 1990s, you had some kind of civil war, domestic violence in the Democratic Republic of Congo, where you had a dictator, I think it was Mobutu Seko, I think, that had been in power and immensely enriched himself. Then I think things were taken over by his son, and then there were domestic unrest. Then the government called in neighboring troops from Rwanda, Uganda, at least. Then this unrest was kind of course, in very unhuman rights friendly ways, brought to an end. Then the troops were asked to leave again. They didn't leave because in Congo there are a lot of interesting things and minerals and forests and coltan, etc., to find. Then the Congo took these neighbors before the ICJ. And the first case that was decided in this matter was a case brought by Congo against Uganda. And in that judgment, the court also dealt with the violation of human rights in the northeastern part of the Congo, which had been occupied by Ugandan troops or by Ugandan, how should I call them, warlords for years. And a judgment was rendered declaring Uganda in breach of not just the prohibition on use of force, but also of human rights, humanitarian law. And what is remarkable is this was the first judgment of the ICJ in which violations of human rights are expressed in the dispositif of the judgment. It means at the end of the judgment, you find the court therefore decides by a majority of X to Y, etc. And there you find violations of human rights and humanitarian law. First case in the history of the ICJ where violations are expressly stated in a judgment. A year later came a case which was less, let's say, welcomed by the human rights community, namely a case by Congo versus Rwanda, that is the next neighboring country in line. And this was interesting because I think it's just a shame to say that this country, Rwanda, which had in 1994 become the theater of a terrible genocide, had become a member of the Genocide Convention after that, but had made a reservation excluding the jurisdiction of the ICJ for genocide. This is just. But what could the court do? What could the court do? Based on the law on reservations to multilateral treaties, it had to conclude and say, well, if a state has made that reservation, this is a reservation which according to the say jurisprudence of the ICJ is not impermissible. And I have to make a square bracket. There were in the years before a number of cases which Yugoslavia, that is Yugoslavia under Milosevic, the Serbian rump state of Yugoslavia, had brought against all kinds of NATO countries that they had attacked Yugoslavia, or they had attacked Belgrade. They had used all kinds of rockets, missiles, and Yugoslavia alleged that in these rockets and shells and grenades, etc., depleted uranium was used for some military purpose, not to have a nuclear weapon cheap, but depleted uranium has some kind of effect on these weapons. They make the shells more penetrate, give them greater penetration, etc. And Yugoslavia brought a case against 10 NATO countries in saying that this, of course, is a grave violation of humanitarian law. The court threw out a lot of NATO countries which had made reservations to the genocide. Oh, yeah, and Yugoslavia alleged that this, of course, depleted uranium in the ground, in the water, was going to poison or adversely affect the youth, the population of Yugoslavia, and that amounted to a genocide. So it's quite, how should I say, courageous interpretation of what genocide is, but that's what they did. The court threw out most of the NATO countries which had done reservations and said we cannot decide the case against these countries. The fact that genocide is the subject of the case, and genocide is really the most gruesome violation of international law that you can think of, does not mean that reservations in that regard become impermissible. You really have to make a strict distinction between the possibility to make reservations and the possibility and the illegality of these reservations. And including the jurisdiction of the ICJ does not mean that that reservation is against the object and purpose of the convention. Not my position, but that's what the court said in 2006. Five judges made a joint separate opinion to that case and said, something has to be done. This is really awful. You shouldn't, if you have a treaty, a modern human rights convention, which has some kind of a treaty body sitting on it and monitoring performance, etc., and violations occur, you can go to this human rights body and some procedure will get in motion. But in case of the Genocide Convention, where the only institution to which you can have recourse against an alleged genocide is the ICJ, to regard a reservation, excluding the ICJ competence, as permissible is outdated and should go. That's what we said in our 5 of the members. Okay, and then finally we reached the genocide case, which was decided in 2007. There are actually 2 genocide cases that relate to Yugoslavia. This was the first one, which had been brought by Bosnia-Herzegovina against Serbia, already in 1993, and which we decided 14 years later. And I can tell you, this gets me back to something I said at the outset. If you are a member of a court which is more resembles a civil court, where parties appear on the basis of parity, of equality, and the things are the matters you decide are things which are within the purview of these 2 parties, like a boundary or damages to be paid. If a court of that nature being confronted by something genocide, the ultra accusation against another state that you can bring under modern international law is going to be extremely burdensome and problematic. And so the outcome of the case was, you can see that in the outcome the court decided that Serbia, we are talking about Srebrenica here, that is an instance where the ICTY, the International Criminal Court for Yugoslavia, situated about less than a mile north of the ICJ in The Hague, had decided that a genocide had happened there. So the court said, yes, there was a genocide there, but the Serbian government, and of course before the ICJ, it's state against state. So Bosnia against Serbia, and the Serbian government is not guilty of having taken part in that genocide. It is not guilty of complicity. It is only guilty of Milosevic not having applied sufficient diligence, not having made sufficient attempts to get Messrs. Mladic and Karadzic, the people in power in the Bosnia Republika Srpska, in the Serbian Republic in Bosnia, to desist from what they did in Srebrenica and killing between 5,000 and 8,000 mostly youngsters in Srebrenica. So this was, and I remember, as judge, there are some colleagues of mine who have been on the court, or still on the court, who say the best thing is you don't tell anything about what you did on the court, how things went, what the atmosphere was. Well, I have been away now for a while, and I think I can afford to say a few things. But let me say that this was a case which really led to a tension in the court that you cannot imagine, and really you could visible tension among members. And only when it turned out that the majority among them, Western judges like myself, would go for that compromise that you say, all right, you're not guilty of genocide, we're only guilty of not applying due diligence enough, then the tension kind of went away. Okay, that's all I can say here. So this gets me almost now what remains of my, I hope that these stories are not too boring, but I try to really concoct out of them the really essential element and not tell long stories. So what we're going to do tomorrow is I'll finish this chapter, the stories, with telling you about the core human rights cases. I can already tell you what they are. There is the Diallo case between Guinea-Bissau and the Congo again. Then there is a case that Georgia brought against Russia following the 2008 military conflict in the country. Then there you have the case of Belgium against Senegal, which is an African case actually. Then we get to the Myanmar case, that is the new genocide case that is currently before the court. And then we'll deal with a couple of cases where you see the ICJ is not under all circumstances ready to give priority to human rights. That is the case of Germany against Italy on immunity of the state, and a preceding case on the immunity of high-ranking officials in a case. It is the case brought by the Congo against Belgium in early 2000. And then we are going to deal with, I'm going to analyze these things and show the context, difficulties, and future chances. All right, I think I kept to the time. I have to say, I should have been about 1 page in my manuscript further, but I'll do my best. Maybe I'll also take a little more time, as Monsieur Pilet did this morning. Let's see how that works. I hope you found that interesting, and I look forward to the number 2 of my lecture tomorrow at the same time. So have a nice lunch. Okay, bye-bye.
Thank you, Professor Simma. It was fantastic. I'd like to thank International Law Center, and especially Professor Leonardo Nemer Caldeira Brandt, and all of you that are listen to us. Thank you again, Professor Simma. Tomorrow we'll have here students to make questions and to make this conversation. I don't know if it's possible to make this more interesting, but I'm sure tomorrow we will learn more and more with you. Thank you, Professor. It was a great honor to be here.
I have a question. It's just out of curiosity. There is Ms. Amina Belten-Guerra up here. Is she representing the students, or is she faculty, or what is your role there, Amina?
Hello, Professor Bruno. I'm coordinating the course with Professor Neyman this year, and I'm also a teacher at Cegim. Great to get to know you. Nice to meet you too. Thank you.
She's the boss, Professor. She's the boss. Thank you.
Bye-bye.
Thank you. Bye-bye. Thank you, everybody. Thank you, Professor Amina. Thank you.